I'm Mike Sitrick, and we're here today with Patty Glaser, a partner at Glaser Weil in Los Angeles and chair of its litigation department. Chambers and Partners describes her as a trial icon and gives her top California rankings in both general commercial litigation and media and entertainment litigation. Benchmark has named Patty, quote, arguably the firm's most celebrated figure and a fearless, quote unquote, lawyer, considered a first call among her wide-ranging client base. Since its inception, Law Dragon has consistently recognized her in their list of the 500 leading lawyers of America. She has also earned the prestigious honor of legal legend, power lawyer, and Hall of Fame legend by The Hollywood Reporter, and inclusion in Variety's Legal Impact Report. Year after year, Patty is included in the Daily Journal's lists of 100 leading attorneys in California, top women litigators, and California's top entertainment attorneys. I've had the pleasure of working with Patty on dozens of cases over our decades of practice in Los Angeles. Since Christmas Eve, the flap between the co-stars of the film It Ends With Us has been the talk of Hollywood and has drawn international attention. Blake Lively accused her co-star and the director of the film, Justin Baldoni, of orchestrating a smear campaign against her with his PR team in retaliation for her complaints against him for inappropriate behavior on the set, including sexual harassment. The lawsuit she filed against Baldoni, his production studio, and his PR team, including scores of texts between them, was the subject of a New York Times article that painted a pretty grim portrait of Baldoni and his team. It's an interesting case because it accuses Baldoni and his team of spreading and embellishing falsehoods about Lively through social media channels. Baldoni claims that Lively and her team took texts out of context to destroy his reputation, and in late January filed a $400 million, 224-page amended counterclaim for defamation against the New York Times, Lively, and her husband Ryan Reynolds. The complaint accuses Lively of conspiring with the New York Times since October, even though he was given only 14 hours to respond to the allegations. Baldoni's lawyer also launched a website that includes the complaint plus a 168-page timeline of events. Patty, what's your take on each side's media and legal position?
I think that everybody should be ashamed of themselves. That's my take on it initially. The PR people, they're acting completely irresponsibly. The lawyers, in my judgment, completely irresponsible. More one side than the other in terms of the lawyering. And I'm just surprised that the lawyer hasn't been sued. His lawyer hasn't been sued for defamation. I guess he is literally shoot first and ask questions later. I think the movie's probably done better than it ever would critically in theaters. I treat the press as I do a jury. I don't lie to the press and I don't lie to the jury because people see through that. And I think becomes less and less effective.
If Lively's contentions are true, that Baldoni's PR people were spreading false information about her and amplifying it, that's very dangerous and, in my view, an unethical practice. We tell our clients that lying to reporters or spreading false information is never the right thing to do. First of all, you get caught and you lose your credibility. The truth has a way of coming out, and lying can not only discredit them, but quite frankly, discredit us because we're representing them. And especially if there's text or video or something else to document it.
I do think that New York Times did their homework. I don't have any idea. I haven't seen anything that has shaken my original view that Mr. Baldoni has a problem legally, but PR-wise too. When Sony immediately backs her, it could be because of Ryan Reynolds, who knows. When WME immediately fires Baldini as a client, it strikes you as that's a pretty big move for players in Hollywood. But I don't know how much of that is attributable to who the couple is as opposed to the righteousness of their position.
Well, the texts are most damning. If you didn't have those texts, you wouldn't have anywhere near this story. The first rule of what we do is recognize that there's a chance that your texts and your emails can get out. So you have to be very careful.
They didn't hesitate texting each other. And the problem is, that old expression, you'll never work in this town again. I don't know how those PR people survive because they have done either a lying job or a terrible job. Take your choice. But somebody is not telling the truth. And it's really ugly. I would never hire that PR firm, either one of them. The thing I'm looking for is integrity. I'm looking for, when I'm hiring PR, I don't have to worry that you're going to step outside the line or over the line. That's so important. I'm looking for fearlessness. I'm looking for people with contacts, real contacts in the industry, so that we can get our story out in a legitimate way. And then I'm looking to the complaint I draft or the answer that I draft to tell my narrative. And sometimes I don't even wait until it would otherwise be due. But history will judge whether they're going to pay for this, the actors and the PR firms. But I'm very concerned as a citizen that the stories are being told made up out of whole cloth. And there's so many ways to get your story out now with the internet that it's really a problem. Today, you can get a bad story or a good story on so many different outlets that it's scary. I mean, 1,000 years ago when Joan Crawford and Betty Davis were known as really, really difficult women, there was a control over the press because it was a much smaller group of people.
It appears that some of the media didn't buy the statements initially put out by Baldoni's lawyer and one of the PR execs. For instance, Matthew Baldoni of Puck questioned the credibility of the PR exec's contention that her campaign against Lively consisted only of contingency planning and was never activated. Baldoni cited texts between her and other members of the team boasting that the narrative against Baldoni had been turned by some of the social media trickery employed by another team member.
I'm not going to mention names, but there's a guy involved in this who I know that's what he does. He manipulates the internet. That's what he does. And I guess he's proud of it. He certainly sells himself that way.
Also, some of the contentions by Baldoni's lawyers that Lively cherry-picked text to put his client in a bad light lacked any examples to make them believable. And his counterclaim with examples to undercut the New York Times story came later, giving public opinion a chance to harden against him. For these reasons, we like to make those initial statements as detailed as possible, and whenever we can, like you would present evidence to a jury, we present evidence to the media.
Matt Baldoni, in my opinion, knows what he's doing, does his homework. I don't always agree with him at his conclusion, but he's a real investigative journalist. This Puck publication I certainly read it with regularity, and they have real people discussing real issues in a timely fashion and a truthful fashion. That's what I'm looking for more in today's world because there's so many outlets, and Puck is a reliable one. Some of these PR firms, which are pretty outrageous to me, they just have people who write fancy prose and don't really understand investigative work. One of the benefits, for example, of Sitrick and company is you've got experienced journalists who know what baloney is when they hear it, and they know if they're hearing baloney, the right questions to ask and the right response in connection with that baloney from the other side. And you're right, hit hard, hit early, hit honestly. You really need to do that.
Baldoni recently released a video of him dancing with Blake, where both of them are joking and being rather intimate between takes. She had described the incident as one of several examples of Baldoni's inappropriate behavior, while he released it to the public to let them decide for themselves. Lively then tried to get the judge to issue a gag order on Baldoni's lawyer, saying he was trying to prejudice potential jury members.
He rejected the motion. However, he gave the parties a very significant warning. I mean, the law is pretty clear for lawyers. You're supposed to not try to improperly impact a potential jury decision.
Where do you think the line is in cases like this about appealing to the public with evidence rather than waiting for your day in court? Because someone's reputation can be destroyed. You can win in court of law, and you can't show your face outside.
You have a trial that I think is not until 2026. So it's sort of baloney that they're having this huge impact on the potential jury, frankly. But it will impact people getting jobs, in my opinion. It will impact grosses at a theater it's going to always be there for these people because Ryan Reynolds is a movie star. She is less well known, but she's certainly an actress. And Baldoni, I can't even spell his name. Who heard of him before this? But you're not going to stop the press, so you might as well learn how to deal with it. But to me, I'm praying for more responsible journalists. I think you're going to see more defamation lawsuits because I think everything from the Murdoch situation in England and a variety of outlets here, they're printing stuff without doing their homework. And I think they are opening themselves up. Lawyers that are out in front of the complaint that was filed or the answer that was filed, a pleading that was filed because there's litigation privilege, are endangering themselves and they're also endangering their clients. I think people are going to say enough already. I hope so. I cannot tell you the number of people who we represent who have been damaged by bad press because today allegations have become evidence. So if I allege that you, God forbid, were a child molester, that's the story. And oh, by the way, a year later, they have unquestionable evidence that's not true, but you were labeled a child molester. And most public figures today, certainly the ones we represent, are concerned about the allegation, not concerned about the evidence. And it's heartbreaking. It's how you undercut a democracy, in my opinion.
Well, that's why you and I both advocate, if you have an allegation against you, a salacious allegation or embarrassing allegation, don't settle until you file your answer. We just had a case where there were 5 or 6 or 7 instances, and with a lawsuit file, settle, lawsuit file, settle, lawsuit file, settle. And then all of a sudden the media got a hold of it and they signed an NDA. So then they couldn't even talk about the lawsuit.
Which is dumb.
Patty, I think we first met in 1992 when Giancarlo Peretti bought MGM and Kirk Kerkorian hosted a business lunch in his guest house that consisted of Kirk, the two of us, and a couple of partners from each of our firms. Since Kirk was a longtime client of your firm, describe Kirk for us.
Kirk Kerkorian was a guy who had an 8th grade formal education and probably was the smartest financial person I've ever met. He actually could see around corners. He was that intuitive, but he also had a great, excuse the expression, BS meter. And he felt that you were not leveling with him or being straight with him. He wouldn't speak to you again. He wouldn't yell. He was not a screamer. He just wouldn't speak to you again. And it was a great lesson for me as a young lawyer to work with him. If you didn't know the answer, you simply told him, I don't know the answer to that question, but I'll get an answer for you. And that's what he wanted to hear.
He owned MGM. What were some of the other properties he owned?
MGM, he owned UA, he owned 30% of Columbia at one time. The government actually sued him in an antitrust case where Kirk was successful. He owned the MGM Grand in both the original MGM Grand and after the new one, the built one, and a whole string of hotels from the Bellagio. I'm sure I'm not remembering them all, but there were a number of hotels. He started with the International, Hilton International in Las Vegas before he owned the other hotels.
And he was a billionaire when there were only very few billionaires.
When that actually meant something?
Well, I remember that lunch, and it was in his guest house, not in the main house in Beverly Hills.
There was a big mansion that he rented out to, at the time, I think, Sylvester Stallone. And he lived in the guest house, 2,500 square feet.
But I remember when we were eating lunch, he gets up and was serving people and say, would you like more of this? As opposed to one of his people who worked for him. I'll never forget that. Yeah, very humble, very nice man.
And the people around him were extremely loyal to him.
So, Patty, let's talk about your background. What did your parents do? Where did you go to undergraduate school? And how did a West Virginia girl get to Rutgers Law School?
Short story. First of all, I'm a hick. I'm from Charleston, West Virginia. Second of all, I was in law school between my second and third year. And I didn't want to do what everybody does, work for a law firm. So I led a bunch spoiled American rich kids to Denmark on the experiment in international living. But before I left, I sent resumes all over the country for federal judge clerkships. And I was fortunate enough to get some offers. One of them was in Los Angeles, never been west of the Mississippi. I'd been out of the country a whole bunch of times. And it was a wonderful opportunity. And it was only a year commitment. It wasn't that big a deal. And I came in, and Los Angeles, in my view, then and today, many years later, is one of the last vestiges of a meritocracy. You don't have to have the right family. You don't have to go to the right clubs. If you're perceived as good, you can do great here.
How'd you get to Rutgers from
West Virginia? Well, I went to American University first, and I went to Rutgers because it was a good school. I started saying it was in New Jersey, where there is no law and order. It certainly wasn't at the time. I clerked for a U.S. Attorney's Office when I was in law school. And there were tons of illegal taping they had done of the mob, especially in New Jersey. And they couldn't use them because they didn't get the appropriate subpoenas to record them. So they'd sit around the office like at 5 o'clock and listen to these guys speak to each other, and your eyes would roll. I don't even want to tell you what some of the things were, but it was an amazing experience. In any event, I was fortunate enough to get an offer out here from David Williams, who was then a federal judge, and had a wonderful year with him. I wanted to go to a firm that had a woman who was a significant player in the firm. So I essentially got it down to two choices. Munger Tolles, because Carla Hills was a senior partner there, very impressive. And Mariana Felser was at a firm called Wyman Boutzer, blah, blah, blah. And I decided on Wyman Boutzer. And by the time I joined Wyman Boutzer, Mariana had scared the bejesus out of a whole generation of men between me and her. About 13 of us left the firm in 1988 and formed the earlier iteration of this law firm. And we have been very fortunate and, knock on wood, very successful.
Yeah, your firm started a year before mine. We started in 1989.
You said, what did my dad do and what did my mother do? My dad started in radio broadcasting.
Oh, is that right?
And was offered, I'm sure he regretted it, but he was offered to be a radio announcer in New York because he and my mother were both from Cincinnati. And he decided to be more conservative and go into a wholesale hardware business in Charleston, West Virginia. Don't ask. He loved that, by the way. But he also was an amateur actor in something called the Kanawha Players. And he let us be in a few of the plays as like little extras. And then my mother was a volunteer for when we were little kids, but then she became head of the State Museum in West Virginia, which happened to be in Charleston. And then she became a director at the Smithsonian in Washington, D.C.
It reminds me, when I was getting out of undergraduate school, I said to my father, I want to go to law school. And he said to me, well, why do you want to go to law school? And I said, I want to make a lot of money. And he said, I'm not paying for law school. That's not the reason to pursue a profession. It made me think about it. And he said, what would you do if you could do anything? What would you do? And I told him I want to do something that has to do with writing and the media. And he said, then be the best there is. You'll do fine money-wise. Don't do something that you may hate.
I'm going to tell a father story also, because it never occurred to me that I couldn't do whatever I wanted to do. I was a little bit of a tomboy growing up, and I'm watching the Cincinnati Redlegs at the time on television with my dad, just the two of us, and I had an epiphany. I look out on the field, and there were no women, girls. And I said, Dad, there are no girls out there. What am I going to do? Because I was going to play professional baseball. And he looks at me without missing a beat, and he said, don't worry. By the time you're ready, there'll be plenty of women. It was a blessing that I had that kind of parenting and from both parents.
What about practicing as a woman when you started, being taken seriously? Was that an issue at all?
You know, it could have been. It largely wasn't for two reasons. One, I'm repeating myself, Mariana Felser, certainly within the law firm. And two, Greg Boutzer, who was a pretty well-known Hollywood lawyer, decided he was effectively my mentor. And he would tell his friends, God damn it, if she's good enough for me, she should be good enough for you. That's how he would introduce me. So all the guys that surrounded Krikorian, for example, and most of them other than Mariana were guys, they all treated me like I was 100% equal. And when you get treated by somebody like Krikorian as an equal and his lieutenants as equals, then the word sort of spreads, and it worked very nicely.
What advice would you give to other women today? Let's say somebody who's in law school or a young associate, about what it takes, well, not just women, but young lawyers.
First of all, a legal education, whether you practice law or not, is only a plus. I think better than before I went to law school. But two, law school is a good training ground. It's very academic, of course, but you have to work hard. I do work hard. And I think that you get better when you work hard. As a litigator, I like winning. Obviously, I like winning fair and square. I like my opposing counsel to be good lawyers, not some of the bad lawyers that I have to deal with. The better the lawyer, the more fun it is, and the sweeter the victory when you beat them. And let's not forget that our justice system is such that hopefully the winner is the right person. And I think you try the cases that you can because you're right. You don't try the cases that you can't because you're sort of not right, and you need to settle the case for the good of the client. And those judgments are made every day. You can't be a 10-speed bike, always in 10-speed. You have to be a chameleon, and you have to really like what you do. And if you don't want to be a lawyer, if you want to write the great American novel, I don't begrudge you that, but don't practice with me. You shouldn't practice at all. Why would you do something 12, 14 hours a day that you were really planning to be doing something else? It doesn't make any sense.
You're well known in many industries, one, of course, being the entertainment industry. So how do you think that social media and our celebrity culture have changed the way you've litigated over the years? And what do you say to clients who can't stop posting on social media when it's going to hurt the case?
Well, first of all, I don't ask them. I tell them and demand that they stop with the social media. But what I've seen as a result of the internet craziness is that I must get an extortion draft complaint at least once a week. And it inevitably is against a high-profile client of mine. And unless you agree to give me $10 million, we're going to file this publicly. Even when there is an arbitration provision in a contract that requires arbitration, they'll essentially file it in court anyway, and oops, and it gets moved to arbitration. So do I believe that the internet has caused this to happen? Yes. It's awful. And there are a few times where you actually have a client say, you know what, I don't care. I'm not going to put up with this. Let them sue. And then I bring in Mike Sitrick and we sit down and we figure out a fulsome response that will actually include, not just deny, but tells a story and tells our version of what happened so that not just the original complaint is going to be on the internet, but the answer is going to be on the internet. And every time they find that horrible complaint, they're also going to file an answer that is, whether it's equally as tough, but it will be very strongly worded that this is nothing more than a ripoff.
Because if you don't do that, right, and you just file arbitration and don't deny and refute what's been said, then somebody does a search and they only see the allegations. And then if you settle, they said, oh, you're just trying to buy silence.
And the arbitration petitions are not public record, as you well know. So, and your response in the arbitration is not a public record, as you well know. So what you need to do is come up with a very pithy answer that literally tells your story, and you can save yourself defamation claims because all you're doing is just somebody quoting from the answer, which is appropriate.
And it also not only saves defamation claims, but news media is hesitant to publish responses like that or allegations unless they have the protection of being able to say it was in a filed case. Your list of notable cases is way too long for this podcast, but let's talk about one where the reporters and where multiple reporters and editors told both my partner Seth Lubov and me that the complaint read like a novel, the Bill Gross case. In fact, Seth, who, as you know, was a reporter at the Journal, a senior editor at Forbes, the LA bureau chief for business for Bloomberg, said that he has never seen the introduction of a complaint as widely quoted and cited as the Bill Gross complaint. And you are known, and I tell people this all the time, for being able to make the complaint interesting and to tell the story. And telling the story, I find and have found over my career to be critical. It's a very rare skill in my experience. What's your thinking behind this?
There's always a story. The discipline you have to have is to develop the story early in a case as opposed to as you're sort of thumping along in litigation. So we develop a story early, and Bill's story is an easy story because he actually is brilliant. He did a masterful job as the Bond King. And for us to tell his story, he made it easy. So we tell his story about why we are where we are with his former company, PIMCO. And the story almost tells itself. But just like a trial lawyer, when I have an opening statement, I have a story to tell. And I'm not going to get your attention as a juror or the trier of fact with just a litany of boring facts. I have to pull them together and it needs to make sense to you early on. And when it makes sense to you early on, I'm going to be doing okay for the client.
Especially in a case like Bill, where he was wrongly criticized and there were inaccuracies about what was reported about him. And it was important to Bill that his reputation be restored and that the truth get out there. We got hundreds of news articles off of that. I think was important.
But Bill's just more visible than most. We try to do that in all of our pleadings, and it matters more for the high-profile people than it does for people who aren't as exposed in the press. But it's a practice I try to get my younger lawyers to do, is tell your story. Don't just take errant facts and pick this and pick that. You've got to pull it together and tell, so you not only obviously believe it yourself, client believes it, but the person reading it believes it.
Well, it's not only the media, because even a divorce, right? A divorce case where the worst things are said in some of these, I don't know how many of them are true, but the worst things are said. You want, when somebody Googles you, and even if you don't get media coverage, to see your side of it as well as what's said about you. And it's equally important to that individual. Patty Dunn, when I put her on 60 Minutes, and Jim Brosnahan said to her, I don't know if we should do this. And Patty said, look, I have stage 4 ovarian cancer. I don't want my grandchildren reading that I was a criminal. And of course, all charges were dropped. So that's, of course, Patty was very high profile being chair of HP. But I think that's an important element that both you and I consider, whether the person's high profile or not. Is that true?
Absolutely true.
Tell me, of the high-profile cases you've litigated, in those that the media played a role, if you had to choose two that you're most proud of, what would they be?
In my mid-30s, I tried a case involving Kim Basinger. And it was high profile at the time. She was a big actress. And the claim was that she promised to be in our movie. And then after a deal was made, boom, she pulls out. And I remember her agent telling her, Ms. Basinger, Kim, you have great legs. That's the best thing going for you. And your legs aren't in the movie, because the movie was about boxing Helena with arms taken off and legs taken off, et cetera. And the person who said that is no longer with us, but he was a great agent and a great raconteur. We sued her and her agency. And the head of the agency summoned us to his office. And he and his partner sat there, and the lawyer for he And Kim was at the other end of the table. I'm sitting there with the producer of the movie who was shaking in his boots because he's in rarefied territory right now. And the agent looks at us and he says, you couldn't even make this stuff up. He looks at us and he says, I would never tell you that Carl, my client, will never work in this town again because that would be illegal and I would never say that. And I looked at him and I said, are you kidding me? You're threatening us? And his partner jumps up and says, he's not threatening you. And I said, sit down. And he said, you're threatening him. And I said, when I threaten somebody, it's clear and there's no question about it. I'm not threatening anybody yet. And I turned to Carl and I said, Carl, I think he's threatening us. Do you want to leave? And Carl's like shaking in his boots. And the guy repeats it. He repeats it. He says it twice. I'm not going to tell you that Carl will never work in this town again because that would be illegal. And Carl looks at me and he said, I think we should go, Patty. We walked out. We then try the case. Her prior agent who made the deal for her takes a stand. I think it's fair to say we ate him for breakfast. He comes off the stand in front of the jury, the judge and everything, grabs my arm, and he says to me, let's do lunch. Who does that? And he meant it. He meant it. Everybody told us you can never try a case against a movie star because they're great actors and the jury will fall in love with them. And it was a breach of contract case. And the jury came back 12-zip on an oral contract and 9-3, which is all you need, on a written agreement. Another one, which was just fun, was we represented Frank Gehry, the architect, who's phenomenal. He's a dear friend and a genius. And we're being sued by somebody. It was a pretty significant guy claiming all sorts of breach of contract and theft and you name it. And Frank was very nervous when he came to discussing legal issues. So it gets on the stand, and instead of starting with the legal issues, we decided that what we do is we talk about the art that he had prepared, this special kind of jewelry that he had designed. And he got really comfortable with that, and the jury loved him. And they loved how he described his process and the whole 9 yards. And we finish our examination, the other side does their examination. And Frank gets off the stand and he grabs my arm again. My arm must be attractive, but he grabs my arm and he says, Patty, you're an artist. That was the highlight of I could stop practicing law right then. You have to love what you do and everything else is icing.
I can remember years ago, I was representing Debbie Fields, Mrs. Fields Cookies. And I hadn't met her. And this is not uncommon where I represent somebody for a year, 2 years. I've never met them, just telephone. This is before Zoom, of course. And so when I finally met her, she said, Mike, when your life is going through, you find your life is going through your hands, through your fingers, it's so important to have somebody to talk to and to talk things through with you. And, sometimes I remember thinking, we take this for granted sometimes, but, what you're doing is you're dealing with people's lives and they haven't gone through this. You've gone through this 100 times even back then, but, this is important.
I don't think there's necessarily a relationship between really good, effective media and effective litigation, because I think a lot of lawyers, unfortunately, more than ever, are using the media to extort big settlements, primarily because people, and I'm sure you see this, allegations have become evidence. And when when you believe the allegations, as sometimes they're horrific, sometimes they're less than horrific, you believe that, then you have to have a Mike or somebody akin to a Mike to counter that because it's horrible stuff.
It's awful. And not most, but a lot of lawyers, and the default for a number of people in my business is no comment. And they'll say, I don't want to litigate this in the press. And I say, it's great if the other side doesn't, or if the media doesn't pick this up. And, we've had cases where we're brought in over other firms and they're saying we're not commenting. And I say, at least find out what they want. No, it's a waste of time. And when we find out, we're able to show it's not true.
It's one of the things I've learned from you, Mike, is it's not ever a good idea to have no comment, but it's also never a good idea to tell something to a reporter that's not true. So there are instances, though, when, and this will be my last example, where I was parachuted into a case to try a legal malpractice case against a major national law firm. And we could have generated tremendous amount of publicity for that case. And I chose not to. Why? Because, but for the grace of God, it could be our law firm. That's one reason. But two, it just seemed like a cheap shot. Either I was going to win this case on the merits or not, but it didn't seem to be the right thing to do was exploit the negligence that they clearly exercised. I've told the story before. The key transactional lawyer is on the witness stand, no press, and I put up on a screen a document that has an incomplete sentence. I mean, it's just like ridiculous that he drafted. And I said, what happened here? I mean, this is clearly negligent. And juries don't like lawyers a lot, so legal malpractice cases are sort of fun in that regard. And I'll do many of them. And he looks at it, looks at me, looks at the jury, and he said, well, I was really reviewing this document at 30,000 feet. And I looked at him, looked at the jury, and I said, well, do you charge the same hourly rate at 30,000 feet as you do on the ground? And the jury's laughing at him. Those are wonderful stories, but you have to know when to hold them and when to fold them. And you need to know when you need the exposure, press exposure, and when maybe it wouldn't be such a good idea if you're looking at a long-term career as opposed to a one-minute career.
Well, yeah, I agree with you. There's no general rule. I was just talking with a new client today, and they said, well, you can take your standard documents and use these. I said, no, you can't, because every case is different. You might have a core, but you have to know, you're right, you have to know what's appropriate for the situation. You have to be prepared, because you never know if the media is going to find out about this on their own. Sometimes they do.
They do.
Well, Patty, thank you so much. As always, it's a pleasure. This was great. I appreciate all of the time.
I hope we can be working together for a long time.
For another 35 years,
yes,
right?
Absolutely.
Right. This is Mike Sitrick with Patty Glaser, and this is the intersection of the court of law and the court of public opinion. Thank you for listening. You've been listening to the intersection of the court of law and the court of public opinion with Mike Sitrick and Sallie Hofmeister. This is a production of Sitrick & Company. To send your questions, hear clips from the show, and learn more about us, follow Sitrick & Company on LinkedIn and visit our website, theintersectionpodcast.com. That's theintersectionpodcast.com. Be sure to follow us on your favorite podcast streaming platform. And if you like what you hear, please leave us a comment or review. Once again, thank you for listening.